Cheval.
Thank you, Mr Chairman. As we've heard, Sir, the bill does seek to integrate our own justice system further with that of Australia's, and as far as I can see, it is the most far-reaching attempt to achieve that integration since the days of Geoffrey Palmer, as he then was, and the mutual recognition that was extended as between the Federal Court of Australia and the High Court as to certain orders and judgments. So it is good to see a scheme that further extends that very pioneering piece of work, which is over 20 years old. One might say that perhaps we've tarried a bit to get to the situation that we're in now, but we are where we are, in large part thanks to the excellent work of Leanne Dalzell and the previous regime. It's great to see that work is being continued. Sarah, I just wanted to have a look at the regulatory impact statement in the legislation and then ask the Minister a couple of questions, because I can see that he's intensely engaged in this debate, and it would be very interesting to hear what the Minister has to say on the questions that I have from. Perhaps the answer lies in his iPad, which he's studying so assiduously. The regulatory impact statement weighs up four options. One is keeping the status quo. One is, we've got the usual excellent quality contribution from Mr Quinn in the committee stages, a learned figure in the House on these matters, so I hope he'll keep chipping in. But as he will know, the regulatory impact statement suggests that there were four options for the House to proceed in this way. We could have kept the status quo, which we clearly haven't decided to do, amend existing legislation, implement changes modelled on the other supranational project of note in the world at the moment, the European Union, with their integration of justice systems, and then the changes outlined in this bill. And the regulatory impact statement concluded, given the needs that it's outlined, that the changes suggested in the bill are the best response to those needs that we have. But as well as identifying the problems within our current regime, the statement does give a wider context as to why the bill's reforms are needed. It does note the increase that there's been in the movement of people between Australia and New Zealand, assets and services between the two countries, and the subsequent increase in cross-border disputes involving individuals or businesses based in both countries. Now, we've always assumed, I think, in this House that that's an inevitable process, that there's an ever greater prospect of integration between Australia and New Zealand. But of course, history shows that that's not the case. We had the politics that was played with the Trans-Tasman therapeutic regime in the last Parliament, and now we've got the prospect of a Conservative government, if it comes to pass in Australia, having promised to have a look again at the ability of people to move freely between Australia and New Zealand for residential and working purposes. That would be a retrograde step. It would be a terrible thing if that agreement were altered. If the special purpose visa that New Zealanders have going to Australia as of right and Australians coming here were to be abolished, I certainly hope that Mr Abbott doesn't get the opportunity to get his hands on that agreement. I think it's been a great thing for the two countries, and I think it would be a terrible thing if that were to come to pass. I think it's unusual that Mr Key rang Mr Abbott on the weekend and left him a message, but didn't ring the Prime Minister of Australia to congratulate her on her campaign. But let's hope that this doesn't presage a change in the trend that we've seen so far to see greater integration between the countries. Well, I think it would be better to hear me speaking on behalf of the country than Mr Quinn, because at least people would be able to understand what I was saying. But anyway, in terms of what our needs actually are in the regulatory impact statement, there are a number of problems which people currently run into, and I want to ask the Minister whether he's confident that those problems will actually be fully addressed by the legislation. The first problem is where a defendant doesn't submit to the jurisdiction of an Australian court, then at the moment the resulting judgment may not be fully enforceable in New Zealand. There's another issue. Final money judgments are the only things at the moment enforceable across the Tasman. There's no ability, Mr Chairman.
Charles Chauvel.
There's no ability to get interim relief, particularly in a commercial sense. You can't apply for the freezing of assets to preserve the position of the parties in litigation when proceedings are based in the other country. Decisions of the tribunals of one country can't be enforced in the other with any great ease, and the rules to determine which country's courts should decide a dispute are based in private international law. The same rules apply there as apply to, say, a dispute involving New Zealand on the one hand and Bolivia on the other, or Zimbabwe, or some other country that we don't have any particular affinity with as far as legal systems are concerned. Clearly, that's not a desirable state of affairs. Also, civil pecuniary fines, as Leanne Dalzell said, imposed in one country are not enforceable in the other, and the same situation applies to criminal fines. So the inability to have that mutual level of enforcement lets certain regulatory offences continue to undermine trans-Tasman markets, ultimately to the detriment of both Australia and New Zealand, because obviously it's desirable to have the same set of general rules applicable in both places. Mr Chairman, obviously there'll be some administrative costs involved in implementing these reforms. The statement recognises that, but it concludes that that will be outweighed by the many reduced regulatory costs to businesses and people doing their activities on a trans-Tasman basis, and because of better enforcement there'll also be, in the end, lower costs. There'll be other substantial benefits, as other members have outlined, including more efficient court proceedings and more effective remedies. The bill will also play a crucial part in the success of the furthering of closer economic relations and single economic market initiatives like streamlined trans-Tasman insolvency procedures. That's obviously a good thing, and the mutual recognition of financial intermediaries. So we should all hope that this integration process does continue rather than grind to a halt or hit some speed bumps because of the internal politics that I've referred to in Australia. And I think one speaker on the opposite side last night did note that New Zealand's been the overwhelming beneficiary of these integration moves, so certainly it is in our interests to be enacting this legislation. But I would like the Minister just to consider in particular clause 51 of the legislation, where the Governor-General by order in Council can declare certain tribunals of a state or a territory of Australia to be a tribunal to which the subpart applies. It's a way in which the executive can extend the application or the intended application of the legislation, and what I'd be interested to know is what types of tribunal the government has in contemplation, if it has any at all, as far as that power is concerned, because it does seem to me that if the full purpose and effect of the legislation is to be realised, then hopefully the sorts of tribunals that are contemplated by that section will be quite a wide one. We will see a large number of Australian administrative tribunals gazetted by the Governor-General in that, under that section, and we will see the ability to have many orders mutually enforced, because hopefully we'll also see under the presumed reciprocal provisions in Australia a similar approach, a similar wide approach to New Zealand tribunals having the ability to have their orders easily enforced in New Zealand, and that would be a good thing. But it would be useful, as I say, to hear from the government and from the Minister and the Chair whether there has been some thought on that issue, or whether we'll just be looking at another hiatus of 20 years before we take the next logical step toward integrating our legal systems.